it's hard to express my gratitude to the Rhode Island ACLU because they helped me in one of the most fundamental missions of a journalist. My name is Phil Eil. I'm a freelance journalist based in Rhode Island, and I am the author of the book Prescription for Pain: How a Once Promising Doctor Became the Pill Mill Killer. The book tells the story of a med school classmate of my dad named Paul Volkman, who is serving 4 consecutive life terms in federal prison for prescription drug dealing. One of the things that makes this case stick out among cases where doctors were charged with illegal prescription drug dealing during the opiate epidemic is that the majority of federal defendants generally, and doctors specifically, take plea deals, and there's no trial. But Volkman, who still maintains his innocence, and who by nature is a very defiant guy who was intent on fighting the charges at every stage, didn't take a plea deal. So there was a trial, and a lengthy trial. His trial took place over a course of about 8 weeks in 2011 in federal court in Cincinnati. His crimes had taken place in southern Ohio, so that was the jurisdiction where he went to trial. And as a journalist, the records from that trial were going to be enormously important to me. Not only is the trial a central part of the book and the story I tell, I take readers inside the courtroom, but that trial, because there were 70 witnesses for the prosecution and 10 witnesses for the defense, there was an enormous amount of information about the underlying crimes that came out. So there were really 2 parts to the trial record. There was the transcript, which wound up being over 4,000 pages, and which I eventually got my hands on and read through. And there were the exhibits, the evidence that the jurors were shown to eventually, they arrived at a guilty verdict. And perhaps naively, I thought because this evidence was shown in open court in a fairly high-profile proceeding that led to this enormous sentence of 4 consecutive life terms, I thought, it should be pretty straightforward. I'll just ask for this stuff. And in fact, in other trials, be they local or federal, you often see court exhibits shared in the media, they appear on the news. I didn't think there would be any issue getting access to this material. That didn't turn out to be the case. I initially asked people at the court, the clerk of the court, the prosecutor, even the judge, if I could have access to this material, and they all told me no. I asked anyone else who I thought might be able to get me access, they told me no. But still, I wasn't particularly put off by that. And eventually I was told to file a Freedom of Information Act request. Now, for the record, I don't think I should have had to file a FOIA request to get access to evidence from a major trial that sent a man to prison for 4 consecutive life terms. And nor do I necessarily think Volkman is innocent, as he claims, but I do think, as a journalist, as a citizen, that we should be able to see the evidence shown to a jury that winds up with a man losing his freedom and going to prison for the rest of his life. That's a cornerstone of democracy, is transparent court proceedings. So I didn't know much about the Freedom of Information Act at the time, but I looked up a template for a letter online. This was my first ever FOIA request. And I sent it off with a description of the exhibits from the trial. I knew what I was asking for. I had access to a 17-page list of the exhibits, but not the exhibits themselves. So I sent off this detailed request February 1st, 2012, and then I waited. And waited, and from there, from that point on, this becomes a Freedom of Information Act story. Initially, the request went to the Executive Office of U.S. Attorneys, the kind of mothership for the U.S. Attorney's Office, which acknowledged receiving the request, sat on it for 9 months before telling me, actually, this request needs to go to the DEA. They charged me for that 9 months of basically doing nothing, about $150 a fee, which I paid. And that was a long 9 months. I had no idea what was coming. And here I was antsy to keep this project going. And the request was transferred to the Drug Enforcement Administration, which was the agency that had investigated Volkman and really taken the lead in the case. And that's where that was the proper place for the request. But it took years for them to continue processing the request. And I say processing, they really didn't send me much. They, every few months, would send me responsive documents, which were really letters explaining that they were withholding the vast majority of the information I was asking for, and what they released to me was often useless. It was, for instance, a slideshow that was shown during the trial about Volkmann's prescribing, how it compared to other doctors. You could see the label of the slide, but all of the content of the actual slide was redacted. You had notebooks from inside the clinic for which they gave me the cover, the back of the notebook, but the insides of the notebook that contained actual information were withheld. Years went by, and I had virtually nothing to show for this request. I find the response I've gotten from the DEA unacceptable, and I reached out to my local ACLU, knowing that the ACLU has a long tradition of being interested in FOIA cases and taking an active role in helping people get documents that have been withheld. The ACLU saw that there was value in this case, believed that these documents were being wrongfully withheld, this trial evidence, and agreed to take on the case. With our lawsuit, which we filed in March of 2015, the Rhode Island ACLU and my lawyers and I were formally saying, hey, we think I, Philip Eil, have a right as, in this case, a representative of the general public, as a journalist, to see these documents. The DEA hasn't given us over years a satisfactory answer. With this lawsuit, we are moving this into the jurisdiction of a judge, in this case, in the local district court in Rhode Island. And so that complaint involved kind of organizing everything we knew up to that point, telling the story of who I was, what I had asked for, what the response had been up to that point, and asking the judge for relief, which was, in this case, we weren't asking for a financial settlement, we were asking for the documents. That's how FOIA lawsuits generally go. Over the next few months after we filed it, we exchanged written arguments with the DEA, and then the following year, in the summer of 2016, I had my proverbial day in court, which was for arguments in front of a judge here in Providence at the federal courthouse, Judge Jack McConnell. And so I had my lawyers, who again I had been connected with by the ACLU, arguing on my behalf why these documents should be released, and lawyers on behalf of the government, the DEA, were arguing why they should continue to be withheld. And then in September of 2016, Judge McConnell issued his ruling, and he ruled in my favor. And that was an amazing day for so many reasons. It was amazing because here, after banging my head against a wall for years, being told, no, you don't have legal access to this trial evidence, having the federal government tell me that, here a judge was saying, no, actually you do. And actually the public does have a right to see this stuff. And actually this is important document. These are important documents. And moreover, the journalism of this kind is important. It's hard to express my gratitude to the Rhode Island ACLU because they helped me in one of the most fundamental missions of a journalist, which is telling stories that are important, that involve the wielding of government power, in this case a prosecution, and that show people what is going on in our courts and with our federal agencies. That was, at the point that I was approached the ACLU, significantly obscured because I wasn't being given access to this material. And the Rhode Island ACLU stood by my side, got me lawyers, and helped me fight this case, and we won. So that it was incredibly validating to have a federal judge. I often joke that it's one of the most validating experiences you can have, to have a federal judge tell you, oh, you're right, actually, in this argument you've been having for years with a federal agency. But more specifically, that ruling and other stages along the way in the litigation prompted the release of documents to me. All told, thousands of pages of documents, as well as photographs and 2 really important video exhibits. Virtually all of that material, with the exception of just a very few pages, was a direct result of this lawsuit. And that material was crucial in the writing of this book. I may have still tried to write this book had I not gotten those materials, but it would have been a much smaller book. It would have had far less detail, and I think it would have had really significant blind spots of what I think is a really important story. So that FOIA lawsuit produced material was just beyond instrumental in the telling of this story.